Welcome to Nava Bharath National Party. Today it is very necessary to understand, can a voter be put under influence of a third party, a strategic company, or an organization which is working for luring the voters in order to poll for any forthcoming elections or general elections. This is very necessary for today's state to understand everyone that is it permissible under law, whether an institution can work for a ruling government or a political party by studying, analyzing the lifestyle of the persons, individuals who are the voters by Indian Constitution, be classified by this type of institutions and prepare political manifestos according to their own will and wish in the form of freebies by luring the voters. Can any institution work? This topic is very necessary today's date to make understand to our public that a couple of days ago there were several news in respect of this political strategists and advisors who are joining hands with ruling governments and also at central level of India. Now the question stands here that a strategy which is prepared by an institution or an organization, will it be permitted to make in the form of a manifesto which is against the constitution of very registration of political party under section 29 of Representation of People's Act? There is a serious distinction and debatable issue today's date that can an institution work for categorizing the voters, for evaluating the number of voters which are going to be eligible for voting after 2 years or 3 years? Is it not covered by section 123, a penal provision of Representation of People's Act, that inducement, luring individuals for the purpose of getting them voted? How far it is constitutional? How far this practice can be permitted to continue in India? Now let us see for a moment about one person by name Mr. Prashant Kishore. He has formed Indian Political Action Committee. Can there be an action committee in respect of Indian politics? Is it not something violatory against Election Commission of India, which is constituted by Government of India in Constitution of India under Article 324 of Indian Constitution? Whether Indian Constitution is superior or a person who is self-declaring themselves to be Indian Political Action Committee, IPAC. Okay, we understand. Maybe the powers of Election Commission of India are larger in nature. They are mandatory in nature. This Political Action Committee, maybe this is it is working for the purpose of, is the platform of choice for students and young professionals to participate in and make meaningful contribution to political affairs and governance of the country without necessarily being part of a political party. Started as Citizens for Accountable Governance in 2013, IPAC has brought some of the best minds from diverse academic and professional backgrounds together and provided them with a unique opportunity to become a part of the election process and influence policy making in India. Can there be an institution which can influence the policy in making India, or government of India will have to make a policy in making India, or a ruling regional governments, as the India is in federal structure and unitary in basis, has to think in respect of making in India? How can a committee which is constituted will think about influencing policy, which is exactly the section 123 of Representation of People Act speaks about? I'll come to that point. In the process, the group helps them to set a citizen-centric agenda and partners with them to conceptuate and implement the most effective methods of taking it into public and gathering mass support. This is nothing but luring individuals and making something that they will do in future, that too entering into with the political parties by making promises or false promises, whatever or so. I have also come across that KCR ropes in IPAC to lead 2023 campaign amid buzz over Prashant Kishore joining Congress. This is a widely published article. It has come in the all newspapers and also in the electronic media. I was just going through this. In this, it has come to understanding that this IPAC has signed for the purpose of consultancy by Telangana Rashtra Samiti. Can this be permitted? Is it permitted? Can this be permitted? Whether it is TRS government or some other government, it is not a matter of fact. If we go and see that if this type of institutions are coming in the way, where does the democracy will go? The participation of public interest in the democratic constitution is by way of casting vote in respect of their own choice, not by way of influence. It is clearly said that the committee itself has been formed for the purpose of influencing the mass. This is wrong. Now let us see what is Article 324 of the Indian Constitution. The superintendence, direction and control of the preparation of electoral rolls for and the conduct of all elections to Parliament and Indian to legislature of every state of elections to the offices of the President, Vice President and all. Therefore, the Election Commission of India has been established for the purpose of superintendence, conduct. Now, the definition of conduct can be derived in many ways. That this type of organizations, if they come into play, if they start influencing, then where will the common man stand? Now, let us see what this Representation of People's Act tells us about the whole of process of elections and its conduct. Corrupt practices and electoral offences. This is falling under Part 7, Chapter 1, Corrupt Practices, Section 123. It may be noted and can be verified. Corrupt practices. The following shall be deemed to be corrupt practices for the purposes of this Act. Bribery. That is to say, any gift, offer or promise by a candidate or his agent or by any other person is a representative status. There these people will come into play, whoever are influencing the masses or the political parties. With the consent of a candidate or his election agent, of any gratification to any person whomsoever, with the object directly or indirectly of inducing a person to stand or to cast a vote. This is what is very thoroughly, clearly stated in the Representation of People's Act in respect of the conduct. And thereafter, after several discussions and deliberations, a very interesting case was dealt by the Supreme Court of India, This is between N. Subramanian Balaji versus State of Tamil Nadu, went up to Supreme Court and decided in 2013. In that, it was categorically discussed that Section 23, what is corrupt practice? Applicability, promises in election manifesto of a political party, promise of freebies, if electoral bribe, inducement, influencing the vote to vote in a particular manner. If that is the case, it is also mentioned here at the paras which are falling in 84. It is, I have highlighted certain parts of the paragraph which is reported in Supreme Court Cases Journal. Therefore, it will be misleading to construe that all promises in the election manifesto would amount to corrupt practice. Likewise, it is not within the domain of Supreme Court to legislate what kind of promises can or cannot be made in the election manifesto. Therefore, Supreme Court also clarified in respect of the manifestos. Now, secondly, the manifesto of a political party is a statement of its policy. The question of implementing the manifesto arises only if the political party forms a government. It is the promise of future government. It is not a promise of an individual candidate. Section 123 and other relevant provisions upon their true construction complete corrupt practice by individual candidate or his agent. Now, coming to this observation of the Supreme Court of India, it can be very clearly said that Supreme Court has clarified and also sent this judgment to the Election Commission of India to prepare guidelines in respect of the election manifestos, because people are promising left, right and center. This writ petition was filed particularly for that purpose only, that somebody promises that the purpose of incorporating Section 123 of RP Act is to ensure that elections are held in a free and fair manner. The gist of the appellants, that is before the Supreme Court, the gist of the appellants' argument that promises of freebies such as color TVs, mixer grinders, laptops, etc. are in form of a part of election manifesto of a political party. If this is allowed, that means if this type of a person or a group of persons making an Indian political action committee and wanted to create influence on the policy making of India, where do we go? What is the purpose of democracy and standing and giving an independent chance for a registered political party to form a government either regionally or in a central manner? There is no meaning, because if the political party who is having a constitution, a future ideology of the party, if they allow these institutions, now a question has to be arised that what is the constitutional validity in respect of persons, those who are directly trying to influence the voter, and parties involving with them and making an agreement, entering into agreements, widely getting it circulated. It is very clearly written, this is formed only because of implement the most effective methods of taking it to public and gathering mass support. Only in order to influence the voters, this type of institutions or persons are coming into the limelight. Now, this is a fundamental question in respect of exercising our adult franchise, that is casting of our vote. Whether are we under some umbrella or a shadow of false promises made by political parties, or the political parties are led by a few persons, those who are influencing them to work in that manner. We have to now very thoroughly see them and scan them and see to it that whether they are really constitutional or unconstitutional, whether they are violating law or not. This is particularly for the purpose of awareness and awakening in the thought process of the voters. Hope you understood. Thank you.